everyone, welcome to House Healthcare on Thursday, April 27th. So we have a bill back from the other body, H473, which is radiologists. They have an amendment. So Legislative Council is here to walk us through the changes. Before Jen goes, this is kind of new for us. So as bills might come back where there's an amendment, the person who originally reported the bill on the floor will report our response to the amendment, whether it's concurrence or an amendment to the amendment. If we sent a bill to the Senate and like S54, we sent over to the Senate and they, that's probably not a good one because I'm not sure we amended that one. S37, we sent back to the Senate with our amendments. They accepted our amendments, so they just concur on the floor and it ends right there. Only comes back to us if they then put an amendment on it. So that's what happened in this case. So I'll report this amendment on the floor because I did the original radiology one. We have 206 coming back to us with some amendments, so that will be Leslie. And then as others come back, if there's any amendments, we'll just know that that's the responsibility of the original reporter. Okay. So 473.
473. All right. Jen Kirby, Legislative Counsel. So I'm realizing, I think I do actually have a markup version because I can show you what I brought into the Senate that they ultimately put in after I'd worked with some stakeholders. So if you remember, H473 is the radiologist assistant bill. And you had heard from the Board of Medical Practice, the Medical Society, and the state's only current radiologist assistant about the bill. And since that time, well, I'll just do what we had originally talked about. There was interest in this. There was interest expressed by some of the stakeholders in making sure that there's some sort of employment connection between the supervising radiologist and the radiologist assistant, so that they're going to, that it wouldn't be an out-of-state supervising radiologist through a supervising radiologist company providing the supervision, but that it would actually be somebody who was had kind of a Vermont, was in Vermont or connected with Vermont and Vermont providers. So let me remind you what you passed. So as passed by the House, you added a new provision in the definition of supervision for purposes of the radiologist assistant chapter, saying, as used in subdivision A, the one that actually spells out the supervision piece, readily available means that a radiologist is available in person or is available remotely by telephone or through a live interactive audio and video connection. And you're going to see that same language, but in a slightly different place when we get to this, what the Senate did.
So I'm sorry, but are you looking at 1.2, draft 1.2?
No, right now I'm looking at as passed by the House.
As passed, thank you.
So then in section 2 of what you passed, you said if a supervising radiologist is not physically present where the radiologist is practicing at that location, then the radiologist assistant would provide services only when a licensed physician who does not need to be a radiologist is physically present at the location and would be responsible for providing intervention or assistance in the event of a medical emergency. That is still in the Senate version. And then you added language saying that the radiologist assistant cannot interpret images, make diagnoses, or prescribe medications or therapies, but may communicate with patients about their preliminary observations around the technical performance of a procedure or examination and about the findings from a radiologist report. And those preliminary observations cannot include any communication about the presence or absence of features or characteristics that would be considered in making a diagnosis. This is also in the Senate version. So I just wanted to remind you of what, and then it takes effect July 1st. So that is in what you had passed. And then so it's still presented as the Senate Health and Welfare Amendment. This is what the Senate adopted yesterday.
This is 1.2.
This is the 1.2. So
we still are seeing something different.
Oh, you are, because I only changed it on my screen. Thank you. Thank you. I always forget that part of it. I'm not sharing my whole computer because then you'd see all my emails pop up. Okay, now we're on 1.2. So the first thing you can see here is that in section 1, we've got this same language about readily available, meaning that a supervising radiologist is available in person or is available remotely by telephone or through a live interactive audio and video connection. But it's no longer in as a 9B. Instead, it's its own standalone new definition number 8. And that's because I'm going to use that term readily available in the next section. So it would just be its own standalone definition. That term is still used, readily available, in the definition of supervision. That's existing law. So this definition of readily available applies to this use of the term readily available. So it's not changing the what happens, how this would be implemented. It's just changing where it lives in the statutory section. So that will make a little more sense once we look at section 2. In section 2, they've added a new subdivision 3. I think we're in A, so A3. A3, again, this is new from the Senate, says the primary supervising radiologist and radiologist assistant shall be employed by and have as their primary work site the same Vermont healthcare facility or an affiliate of the facility, provided, however, that the primary supervising radiologist does not need to be physically present at the same location where the radiologist assistant is practicing, as long as a supervising radiologist is readily available. That's why the definition got pulled out to be its own definition for consultation and intervention. So this introduces, for our discussion purposes, but not new to the chapter, the idea of a primary supervising radiologist. There can be more than one supervising radiologist for a radiologist assistant. So this is creating a new requirement that the primary supervising radiologist and radiologist assistant must be employed by and have as their primary work site the same Vermont healthcare facility or an affiliate of the facility. But then we're reiterating this reminder that both the primary supervising radiologist, and in fact, any supervising radiologist, does not need to be physically present where the radiologist assistant is practicing, as long as a supervising radiologist doesn't have to be the primary one. Primary one's basically the one who signs the paperwork that says, I am the primary supervising radiologist. As long as a supervising radiologist is somebody with whom the radiologist assistant has this supervisor-subordinate relationship, is readily available for consultation and intervention. As hands go up, I will pause there.
Affiliate, wait, can you scroll up to the affiliate facility part? Is that something that's defined in statute, affiliate of the facility?
It is not a defined term. I would be a little concerned about trying to define it. We talked about it in the, there are affiliates of facilities. It's sort of a greater relationship between a facility or between, between facilities or between settings than just a contractual one. It's some sort of, there are definitions elsewhere in statute of affiliates. There's usually some sort of parent corporation or ownership connection between the two. So that's what an affiliate is. So, and the example that kept getting given of how this would work is you have perhaps the radiologist assistant at Porter Medical Center and the supervising radiologist at UVM Medical Center, and those are affiliates of the same facility.
And I think what they're trying to avoid, correct me if I'm wrong, is radiologist assistant at Porter having the supervisory radiologist be from Montana.
Exactly.
No connection.
Exactly.
Who would be reviewing charts digitally from afar?
Well, no, it's the relationship between the two, right, Jen?
Right.
Right. Not what they're doing, but there has to be a relationship.
Right. So that the patient is a patient of the sort of facility network, or so the main ones that we have in Vermont are the ones affiliated with UVM Medical Center and the ones affiliated with Dartmouth Hitchcock Medical Center. So for our purposes, if we're licensing this person, this radiologist assistant, then they have to be having as their employer and primary work site the same either actual facility or affiliated facilities.
Lori, is the intent that the supervisor actually has a connection to the patient in some way?
I don't think so. I think it's just to make sure that there is a real connect. And, I think the medical society or UVM would do a better job of explaining the rationale for this language, the why of it. But it's my understanding that there was concern about there not being kind of a robust enough supervisory relationship if there is not. They didn't want to literally require that the supervisor be physically located in Vermont because they could be in an affiliated facility in New York or New Hampshire or Massachusetts, but that they would be somehow connected and would have responsibilities in the same kind of chain of command.
Leslie, and then Topper, and then Art, and then Alyssa.
Oh, okay.
So my question comes from, like, it's in the middle of the night and the radiologist assistant is covering, and the coverage is remote because that could happen in the middle of the night in certain sections. And I understand that would not necessarily be a supervisory relationship. So I'm just trying to understand if that's legitimate within this statute to have that kind of coverage.
I'm not sure I understand the
Well, let's say.
remote radiologist assistant covering.
No, not the remote. The radiologist assistant is doing their work in
Okay.
order. But it's the middle of the night. Well, I'm thinking about Springfield Hospital. It's rural. There's no one there. But the coverage comes from a remote radiologist, maybe in Montana, just for that night. Are they?
That would not be allowed under, so the supervising
That
radiologist,
would
the
be-
person who has to be readily available for consultation and intervention. The definition of I think radiologist under this is a Vermont licensed provider.
Okay, so I'm not saying we should change it, but I'm concerned about rural hospitals that are not UVM or not DHMC who need coverage when there aren't radiologists available that are Vermont licensed, blah, blah, blah.
So I think that really is about the supervision. And I think the supervision, I'm just trying to, so supervision is direction and review by a supervising radiologist as determined to be appropriate by the board, but I believe the definition of radiologist, stop my share for a minute here so I can look at the statutes. So the definition of a radiologist is someone who is licensed, either licensed to practice medicine or osteopathy under our statute, so a Vermont licensed provider, or who is credentialed by a hospital to, so I think it's a question for the Board of Medical Practice, but we don't
need to pursue it right now, but that is a wondering of mine, like the rural hospitals.
Right, I think the intent is still to have it be a Vermont licensed or a supervising radiologist, somebody with whom they have a relationship,
Which is what it is today.
which is what it is today.
I'm thinking about PAs, like PAs have a supervising, or they used to, and that may have evolved away from that a little bit, but they still practice when that supervisory person isn't around and they're off site and whatever. And I didn't know, I think that they were looking at a similar kind of dynamic.
So I'm gonna turn to Mari real quick.
Yeah, I think I have an answer for
Okay.
this. So radiology assistants aren't the only ones who can perform ultrasounds in rural hospitals like Springfield, where they may not even have radiology assistants.
There's only one and she
There's only
doesn't
one,
work.
yeah, two or
What's that?
three.
There's only one and she doesn't work there, so that currently.
The current state is.
There are other people who are qualified and skilled in performing ultrasounds if there's an emergency where one needs to be performed and read.
Oh, we're not talking about them. We're talking about radiology assistants. But let's let that be, because I don't want to divert this.
Radiology assistants are not so much like emergent
Right.
situations, if there was a need for a person to see a radiology assistant, they could go to a place where there's only one radiology assistant.
No, I'm just looking at the forward. I understand.
Okay, well,
I'm just thinking forward as, you know, the world evolves and that will change a lot. I mean, but
Art,
Oh,
I'm sorry. I'm gonna let you go because I skipped Tupper, so I'll come back to Tupper. Go ahead.
who wanted this language in?
This was a request from the, I think it came jointly from the Medical Society and the UVM Health Network, and then got approval from the Board of Medical Practice.
Okay,
It's everyone who originally wanted the language anyway has agreed to this language.
gotcha.
Yeah.
And are all hospitals in Vermont all affiliated?
No,
No.
Okay, so no, so somebody in Brattleboro, if the thing was in Porter, like you said, somebody in Brattleboro then could not.
right.
Okay. Does that put us in a box? I don't know. Okay. I mean, if they wanted it, I guess they want it. Whatever.
Yeah, I don't think it puts us in a box because we're still allowing more than what we had originally in legislation.
Just didn't want us to get too narrow.
Right.
so I'm agreeing with that because it's limiting to Chittenden County or maybe Dartmouth,
I'll
but
go with the crowd on it.
yeah, I mean, but not that we're going to change it, but I just want to think about it for the future. As maybe, because they want to expand this role.
Can I just clarify? In 3, it says the primary supervising radiologist and radiologist assistant shall be employed by or have as their primary work site the same Vermont healthcare facility or an affiliate of the facility. So it would be Brattleboro Hospital or Springfield Hospital. It's just that if it's Porter, it's connected to an affiliate.
Right.
Or if it's whoever's connected to Dartmouth, it's an affiliate.
Right, they're in different, but they're not all one in the state. They're
right.
all, okay, yeah,
Right.
Right.
whatever.
Tupper?
That, what you just talked about cleared it up a little bit for me, but maybe, I read 4.
Sorry?
I read 4. I was reading ahead of you.
Oh, well, 4 is what you passed.
get to
4 is
4.
what we originally passed. But go ahead, so that's your question.
Oh, okay. All right.
And that's-
In there, it says, where does it say it? Someplace it says that if the radiologist that's the supervising radiologist is not available, then it appeared to me that when a physician licensed pursuant to Chapter 23 and 33 of this title, who need not be a radiologist.
Right, so that's different, because in number 3, we're talking about the primary supervising radiologist does not need to be physically present where the radiologist assistant is practicing, as long as a supervising radiologist is readily available for consultation and intervention. So that's all kind of focused on the radiology piece of it. Number 4 says if a supervising radiologist is not physically present where the radiologist is practicing, then there has to be, the radiologist assistant can only provide services if a physician, who doesn't have to be a radiologist, is there and would be responsible for providing intervention and or assistance in the event of a medical emergency.
Yeah, that's what I'm wondering about.
So that's the piece that says it can be, right, so that's the piece that says radiologist assistant can't do anything if there's no doctor on site. Because if some kind of medical emergency arose, there needs to be a physician there who can administer emergency aid, you know, or provide emergency services. So it doesn't have to be a radiologist who's there just so that the supervising radiologist can do something. There could be a supervisor who's remote and is available for the radiologist assistant to call or Zoom with questions about what they're doing for radiology. But if there's a medical emergency with the patient, there needs to be a physician who's on site.
Other than the radiology part of it. Let me tell you why I'm asking this question now.
Okay.
When I was going through the treatment, something happened when they were providing the radiation, whatever it's called. And they stopped everything. And there was a doctor there, But that doctor couldn't tell that radiologist, that assistant, how to do it. And they waited for a radiologist to help the person.
So that's exactly what this allows, but if you had gone into cardiac arrest while that was
Okay, so
happening,
it's-
that's why we need a doctor.
All right, so now I understand it now. So it's only if it's other than the radiation that's going on. It's another, like a heart attack or something like that.
Right, there needs to be a doctor on site, doesn't have to be a radiologist. Radiologist can be available to consult the radiology part of it by phone or Zoom, but there needs to be at least a doctor physically present at the same location where the,
So medical emergency has nothing to do with the radiation being given to you.
has nothing to, it likely has nothing to do with the purpose of the procedure you are there for.
Understand now.
Something that comes up during that may or may not be related.
And so, and I just want to remind everyone why we included number 4, because before, correct me if I'm wrong, Jen, the supervising radiologist had to be on site.
Right.
So in that circumstance, the radiologist, under current law today, in your circumstance where a supervising radiologist would need to be consulted about what just happened, that supervising radiologist had to be on site to do the connection. But now we're saying, well, you can call or have a video with someone or, yeah,
Because this guy had to come from
yeah,
the hospital
right.
over.
So now we're saying that doesn't have to happen. You can get immediate connection to a supervising radiologist by phone or by
I
video.
get that.
Okay.
I get that. I just wanted to make sure that that intervention that was being done by that non-radiologist MD didn't have anything to do with the radiation part of what's going on.
So this doesn't, I mean, if it was within the scope of practice of the physician, non-radiologist physician who was there, perhaps they would be involved, but it's not requiring that there be a trained radiologist, supervising radiologist physically present, or any radiologist physically present, as long as there is a doctor physically present. I feel like I'm not answering your question, but I'm not sure.
They're not going to continue with the radiation, right?
I think it's going to be very fact specific.
Yeah.
And you're talking about radiation, like if you have cancer.
That's what it was.
So that's a different thing than a radiology assistant. A radiology assistant doesn't usually do radiation oncology. That's a separate field of practice. Radiation, can I?
Yeah.
If I go ahead, sorry.
Yeah, please.
I am not a radiology assistant, obviously, but in my limited understanding, there are some procedures, limited procedures, minor procedures where there is a benefit to having radiologic imaging to guide the process of
Where they give you the radiation, they put tattoos on.
there's no radiation like that at all. So X-rays are radiation. You get radiation with X-rays. You get radiation with other imaging, with
Scans.
if you have a stent placed in your heart, you get radiation then, so they can see what they're doing on the screen when they're putting the stent in. That's all radiation, but it's completely separate from being treated for cancer with highly focused radiation to that site.
Yeah, but I get all that.
The
What I
radiation,
don't want to happen is a doctor that is not trained to do that intervening.
That's not gonna.
That's,
Right.
yes, that's not what we're.
That's not what this allows.
I read this
This
and
is
said,
really saying, this is really limiting the circumstances in which a radiologist assistant can practice to, at a minimum, there must be a physician physically present in case something bad happens. That's beyond the scope of the radiologist assistant's ability to help with. So radiologist assistant can't be, alone in a room with a patient with no physicians anywhere else in the building providing services. There has to be a physician on site.
And that's already in our language, correct?
That's in your language, yes. That's 4 is the old 3, that from when you passed it, yes.
All right, any other questions?
And there are no other changes.
It
was around the, I think we kind of answered it, the Vermont thing. I was just thinking, does the primary facility have to be Vermont? And does so like in the case of Dartmouth, it's.
A Vermont healthcare facility or an affiliate of the facility.
Okay, so the radiologist and the radiology assistant do not have to have as their primary work site, the Vermont portion of the facility, if the main facility is in, say, New Hampshire.
Well, I'm looking at it's an interesting question. I'm looking at the language where we say the same Vermont facility or an affiliate of the facility. I had interpreted it, or I had understood it because of some of the examples that were given as being, could be Dartmouth Hitchcock with Vermont affiliates, but it's a little unclear.
I read it over about 100 times.
Now that you say it, it's a little unclear.
Yeah, because it could be Dartmouth and a Scutney.
Also, I'm thinking about, does the supervising radiologist have to be licensed in the state of Vermont to be the primary supervising radiologist? Because if you're practicing mainly at Dartmouth Hitchcock, although I'm sure that, don't they license all their providers in Vermont? I think, I'm not sure, but could you be a radiologist in New Hampshire, licensed only in New Hampshire, and be the primary
I believe so because of the definition of radiologist in this chapter. Need somebody licensed under, well, that language is a little unclear as well. I'm saying that, but it does also say, or who is credentialed by a hospital to practice radiology and engages in the practice of radiology at that hospital full-time. So I don't think, so yes, I think if it's allowed under the board rules, under the language, you can have the primary supervising radiologist or a supervising radiologist be licensed in the other state and not in Vermont.
Let's start a compact.
All right, we gotta stay focused because as soon as Katie comes in, we're switching.
Yes, and I have to get downstairs.
I'm just not sure. I'm not sure if the language makes it clear that it's okay to be in different states.
I think that is a valid point. Let me circle back with Board of Medical Practice and others and see what their read is, and we may need a small amendment.
Okay. And did you have?
I have the same concern.
Okay.
And here's why I have it. The primary supervising radiologist and the radiologist assistant shall be employed by, and it goes on, and have their primary work site the same Vermont. Doesn't say any other state. It says Vermont Healthcare Facility.
Or an affiliate of the facility. So the question is the affiliate of the facility, does that limit it to Vermont facilities? Arguably, it's not clear about whether Vermont modifies, healthcare facility or, I think it's unclear what Vermont modifies. So I want to check in with the folks who I worked on this with and see if we need to do something to clarify that.
Thank you.
Because I think I'm hearing from the committee that you do not want it to be only a Vermont facility if it's an out-of-state facility with Vermont affiliates.
Let's be clear. We want Dartmouth to be able to be, yes.
Yeah, that's what I'm saying. It could go the other way, like think about a Scutney. A Scutney is affiliated with Dartmouth.
Right, that's what we're talking
It
about.
could go that way too, not only the other, not only.
That's all we have control over
Yes, is right.
Vermont
There's
licensed
a
providers.
in New York,
Yeah.
UVM Health Network affiliates in upstate.
But
Yes,
UVM is a
practice, right, but when the practice is, right, but Vermont is the healthcare facility, it's a Vermont healthcare facility with New York affiliates, not a New York facility with Vermont affiliates.
Right.
So it's really the.
That's what I'm wondering.
Vermont
Could be a
question.
Vermont facility at Scutney with a New Hampshire affiliate at Dartmouth with that direction. I'm just thinking about direction.
Then we're fine with the Vermont healthcare facility
That's what
piece.
I
It's
mean.
really,
That's what I mean. Yeah, it goes the other way. It goes both
I think
ways.
you know.
I think I understand what's happening, so, yes.
Thank you, Jen. I
Yes.
appreciate that. So you'll get back.
I will get back to you.
Appreciate it.
Yes.
All right, so we are going to switch to S89. So we're gonna give Katie a minute to come to catch her breath, I'm sure, as well as be ready to come up. And so I wanna, I think the plan, Katie, is to potentially walk us through what judiciary has done.
Okay.
And then I want to remind people, our role here in this committee, we don't have jurisdiction. I mean, we don't have possession of the bill, we have jurisdiction, some piece of it. Our role is, do we believe that Vermont needs to have a forensic facility to help people who come under the care of and custody of the Commissioner of Mental Health? Okay, we're not doing the intellectual disabilities, developmental disabilities, we're doing this piece of it. And if yes, are we good with the policy that's being presented to us in the legislation? So with that, I'm going to say Human Services has taken a lot of testimony and they have provided language to judiciary for their piece. My understanding is that they're taking out a lot of their piece and putting in a study group because they feel that you have to remember their world is a little bit different. They have something called Act 248, which sets up space and community with wraparound services for that population. We don't have that in the mental health in the same way. So they're doing that. And then Institutions and Corrections has looked at it in regards to like the facility itself. So are they able to separate in the appropriate way? What are they going to require? And so they're giving language to judiciary for that piece. I don't know if I don't know if that's in there yet, Katie.
No.
Okay. And then we're going to look at, okay, so do we feel that for mental health treatment, this is a potentially proper place for some people to be in custody for their treatment? And then there's a specific piece about certificate of need that we need to look at. So all that being said, we need to keep our area focused and move forward so that this bill can move forward if it's meant to move forward through the other committee. Okay.
What sections then are we concentrating on?
Let's let Katie come up and we'll.
Tell us that.
Yeah.
And you said that they're doing a study, that's why they want their work to move forward? I believe, I have not seen the language yet.
And just to be clear, we're not mixing
No,
47 and 89.
we are not mixing 47 and 89. Although I had a dream last night.
You were thinking of me.
I was. So someone's like trying to put them together. I was up like 2 hours. Like, wait, are we doing that?
If I may understand the policy questions, yes or no, and then there's a second question, which I just want to clarify. The second question is.
So I believe the language is asking for the CON to go away for this. I don't know if Susan's here to testify potentially for that. I asked her to do some checking. So I think we'll work with Katie and then I might take a short break and talk to Susan. But the question will be, do we say that a CON is needed or not needed? And just this one
Those
or?
are the two questions.
Yeah.
Okay,
Yeah.
thank you.
I mean, there might be more once we go through the language, but that's general.
Good morning.
Good morning. Good morning.
Katie with the Office of Legislative Counsel. We just discovered the wrong version is posted, so
Okay.
getting the correct version posted. Oh, you have it. Great. It's 3.1.
3.1, you said? Kate?
Yep, it's not posted. Yep, Claire's posting it right.
Okay, so in the meantime, I'm going to enjoy your blue color because that's a great color.
Oh, thank you.
This is 2.3 we got.
It is, and Claire's gonna post
All right,
3.1.
gotcha.
Thank you. All right, let's start while Claire's posting it.
Okay.
Oh, you don't have it yet either? That's fine, I'm sorry. No, you're fine. You're fine. Everyone just go a little deep breathing.
Breathe in for 4, hold it for 7, breathe out for 8.
That would make me pass out.
4, 7, 8 breathing. 4, 7, 8 breathing lowers your heart rate.
Never really got the. Okay, let's see. I think.
what I can do is sort of give you a reminder overview. Will that work?
Oh, that's great.
So,
And before you start, do we have you until noon?
yes.
Oh, great, okay.
So I know we walked over the section by section summary of this bill. We did kind of a high level, but we didn't really look at the words yet. But the concept behind the bill is that this creates a new category of facility. The bill that came over from the Senate had kind of dual custody over the building or facility by Dale and DMH. And as you heard, Human Services moved in the direction of not having individuals with intellectual disability served at a forensic facility. But the sort of concept at the moment is that, right, the Vermont Psychiatric Care Hospital currently has 3 units. The idea would be that one of those 3 units would no longer be licensed as a hospital and would be licensed as a therapeutic community residence, which is a license type that Dale administers. So Dale would still be licensing the facility, even though at this point what you're considering is individuals in the custody of the Commissioner of Mental Health would be using the facility, which is not unusual because that's the motto we have for the Secure Residential Recovery Facility. So there's precedent for that. Most of what you have in your section that you're going to be looking at is how to integrate procedures to put somebody in a forensic facility, how to integrate that language into existing admission and commitment statutes that are already existing in the mental health chapter of Title 18. So that is all the language we looked at yesterday, or conceptually that we looked at yesterday. That process and that timeline, what we're doing is just integrating the forensic facility sort of into that statutory language. Now, let me see if I have.
This is a prefacing question, it would help me as we go through this. If someone could remind me of who the people are we're talking about, what are the criteria for them to need a forensic facility, and what is happening to these people now? Do we have anywhere for them to go now?
I can answer the first question and I can touch on the second, but I would have you get the expert answer from DMH. So in terms of who is served by this facility, when we met yesterday, had the slide of different arrows coming into a hospital. So one of those arrows coming into the mental health system was forensically involved individuals, so individuals involved in the criminal justice system. So it would be serving that population. It would be individuals who are either adjudicated not guilty by reason of insanity, or individuals whose case has not been adjudicated because they've been deemed incompetent to stand trial. And just a reminder that if somebody is deemed incompetent to stand trial, that is sort of a point in time assessment. It can be determined at a later time that that person is competent to stand trial, in which case, under this bill, their custody could transfer from DMH back to corrections, and the person's trial could happen. These are, where are these people being treated now? I would probably, you'll get a better answer from DMH, but probably a combination of in a correctional setting or in the custody of the commitment of DMH if they meet the criteria for involuntary hospitalization.
So more specifically, potentially these could be people who have committed violent crimes, including murder.
Yes.
Potentially. Yeah, so they'll,
Alleged.
yeah, unless they've been adjudicated not guilty by reason of insanity, then they're using that defense. And then the language that we'll look at, it talks about the serious risk that the person poses either to themselves or to others, so as to warrant them being a resident of a locked facility of this sort. So we'll look at that language, but there's also like this degree of dangerousness that is under consideration when a determination is made.
Brian and then Leslie, and then we're gonna start.
I wanted to give, no, I'm not a witness, but I wanted to give an example of a situation of one situation of where like a forensic facility might help a person. I've worked with people who have psychotic illness and they commit a violent crime when experiencing the psychosis, and then they end up in jail, and then jail exacerbates the condition. And so they do not regain competency. So they just languish in jail and never go through the court system in like a appropriate way or expeditious way or quick way or whatever. So having a forensic facility where a person could go and be stabilized would help it would help the process move along, and also for that person's wellness, it's just better. My only concern is what next, because like jail isn't necessarily the best place for people, and I don't think we have enough secure residential facilities, but that's not in this bill. So I will stop there with that, but I hope that helps, like just hearing one specific example, because there's probably many examples like that.
Thank you. I just want to understand, could a person be in a facility like this, if they've committed a crime, they're charged with first-degree murder, pending psychiatric evaluation, could they be in the forensic facility pending that?
So this is at this point, I mean, the person has already had their assessment and their emergency exam. And in order to be committed there, they have to have the whole judicial proceeding with an application for involuntary treatment, and the court is weighing in. So at that point, the person has been assessed multiple times.
So prior to that, they're going to be in another piece of the system, like a correctional facility or whatever.
Potentially, yeah.
Thank you.
And just to jog your memory, the way this is written, we refer to a forensic facility, not the forensic facility. So this language is sort of open-ended in that there could be future multiple forensic facilities. So this purpose language is what I sort of already alluded to. It's the purpose of the act to enable the commissioners of mental health and Dale to seek treatment and programming for certain individuals in a forensic facility. An initial forensic facility is to be located in the 9-bed unit at the Vermont Psychiatric Care Hospital, and this would be relicensed as a therapeutic community residence. Okay. So the version we looked through was the section by section summary that came over from the Senate. The Senate version had a rulemaking section that required the two departments to adopt rules about admission criteria and the admission process. This draft gets rid of that rulemaking section and instead tries to embed the admission criteria and process into the statutory language, so there wouldn't be a need for rulemaking. So part of doing that is the creation of this Human Services Community Safety Panel, which is a panel of individuals, commissioners really, who would be assessing if there's an appropriate placement for a person in the at the forensic facility. So this is creation language. There's hereby created the Human Services Community Safety Panel within AHS. The panel shall be designated as the entity responsible for assessing the potential placement of individuals at a forensic facility pursuant to the criminal statute for individuals who present a significant risk of danger if not held in a secure setting, and are charged with a crime for which bail is not available, or were charged with a crime for which bail is not available and adjudicated not guilty by reason of insanity. That's the population of people. And then the panel makeup. The panel shall comprise of the following members: the Secretary of Human Services, the Commissioner of Mental Health, the Commissioner of Dale, and the Commissioner of Corrections. Panel is to have the technical, legal, fiscal, and administrative support of the agency and the three departments. And then we moved.
1 second, Katie, Deborah.
All of these people, did they have psychiatric assistants to do their job? You know, somebody who knows what they're talking about. I can't see the Commissioner of Corrections as an example, making a decision.
I don't know how to answer it. Yeah, I mean,
Who supports that panel?
who supports them? Their own staff. They have medical director at DMH, who's a psychiatrist.
And human services,
Okay, as long as they have people that,
Yeah.
it's not just the commissioner sitting around
No.
saying, oh, this one goes here.
Well, it's a interesting point, so maybe the panel have medical, add medical, or it has legal, fiscal, administrative, but doesn't say medical.
Hold on.
interesting.
Look.
That wouldn't be covered by technical or administrative
I don't know that it would, I mean, technically.
I don't know if it would either, yeah.
I don't think it would be.
They're just focused on assessing the potential placement of individuals, right?
Right.
So they're responsible for getting folks to a safe and secure.
There'll be more language on their role later on.
Okay, let's keep going. And
DMH already does this though with
they do.
placement, so if
Right.
there's, I would just trust that if the Commissioner of Mental Health is on this group, they're gonna be accessing the
already
medical
doing it.
staff,
All right,
but
but let's hold that question as we keep going.
Okay. So then we move to Title 13, the criminal justice statute. And it says that the person who is subject to the proceedings, the person's attorney, the legal guardian, if any, the commissioner of mental health, the commissioner of Dale, the state's attorney or prosecuting officer representing the state shall be given notice at the time and place of a hearing. Procedures for the hearings for persons with a mental illness shall be provided under Title 18. Procedures for the hearing, we won't have to read that. So this is existing law, but yesterday we talked about how people coming through the criminal justice door, their proceedings sort of started in Title 13 and then it's transferred over to Title 18 and we follow the same process in Title 18. This is the language that's making that transfer. And we have new language in subsection B. Once a report concerning competency or sanity is completed or disclosed to the opposing party, the Human Services Community Safety Panel may conduct a review on its own initiative regarding whether placement of the person who is the subject of the report is appropriate in a forensic facility. The review shall inform either the Commissioner of Mental Health or Dale's decision in whether to seek placement of the person in a forensic facility. So it would be the commissioner who ultimately is seeking the placement in a forensic facility. So that group, the members of the panel, is making, helping the commissioner who has, in this case, DMH, determine whether they should be making that recommendation.
Because that person would then be in the commissioner's custody, right?
So the person would then be in the commissioner's custody. So just like a commissioner is the person, the commissioner of mental health is the person applying for an order of hospitalization or non-hospitalization. They're the ones who would have to specify, we want order of non-hospitalization in a forensic facility. So the panel is providing advice to the commissioner as to whether they should make that request.
Sorry, and then Leslie.
Who is the opposing party?
Um,
What's that?
Maybe the defender, not the state's attorney. Let me look, sorry, the opposing party. Maybe the person representing the client.
There's an assumption that there would be opposition.
To the placement potentially.
Yeah.
Yeah, so if the AG's office represent on behalf of Dale is bringing the commitment proceeding, then Vermont Legal Aid would be representing their client, the person, and potentially saying that commitment is not appropriate or medication is not appropriate, whatever.
and if not, it sounds like it says when it's completed, so if there's no opposition, they still move forward once the report is completed.
Yes.
Because it's or, not and, so like
Sure, where you're,
at the beginning of
are you in A?
I'm sorry, I don't know if I'm in the same thing, but if you go down to B,
Oh, you're in B.
yeah,
Yeah.
I was looking at the language in B, it says once the report is completed or disclosed to the opposing party. So if there's no opposing party, once the report is completed, the panel may conduct a review. So they can conduct a review even if there is no opposition.
And so this B1 is all about the panel just initiating its own review. They're aware that this person is in the system and potentially the right placement as a forensic facility. And they've just decided that they're going to do their own review to, should we make this recommendation? Two, oops.
Oh, sorry, Leslie and then Melanie.
Yeah, I'm sorry. I'm just a little confused because the community panel, is the commissioner, are the commissioners, so they're informing themselves? I got just confused about that. How does that work?
That the four commissioners, well, one's a secretary, so the four would meet and have, have a discussion on the criteria that we're going to go over and make a recommendation to the commissioner.
Right. And then because the commissioner is ultimately, if the person's going to be under the care and custody of the commissioner is ultimately the one.
Okay, I just got confused about them informing themselves, but I guess that's.
It's informing their decision, it says.
Right.
It's informing, the review's informing their decision. It's like an extra level of process where they're getting like peer supervision from other colleagues on their decision. That's how I'm taking it.
Yeah.
Okay.
Yes. I mean, that question came up yesterday in human services.
So is this where you said whether or not the person should go to a forensic facility? Does that mean that this is when if they were developmentally disabled, they might go to a different place? Is that where?
So this language is only specific to mental health. I know right now we still have language integrated referencing Dale, but it will be removed and the language you're looking at moving forward will only be mental health language. Yeah. Okay. So B2 anticipates that there might be a situation in which the panel does not initiate its own review, in which case a party to the hearing, so the parties listed in that subsection A, may file a written motion to the court requesting that the panel conduct a review within 7 days after receiving the report or within 7 days of being adjudicated not guilty by reason of insanity. So that means one of the parties to the case can say, wait a minute, we think the forensic facility is the appropriate place for this person. The panel is not looking into this. Court, can you tell them to look into it? Can you tell them to do a review? And then in B, subdivision B, I guess 2B, a motion that's filed shall specify that the person who's the subject of the proceeding is charged for a crime with which there's no right to bail and may include a person adjudicated not guilty by reason of insanity and that the person presents a significant risk of danger to themselves or others if not held in a secure setting. Then in subdivision C, we have the court ruling on that motion. The court shall rule on a motion filed pursuant to the subdivision within 5 days. A panel review ordered pursuant to the subdivision shall be completed and submitted to the court at least 3 days prior to the hearing. Okay. And then when we move into subsection C on line 8, this is what the panel is doing when they're consulting with each other. So in conducting a review to seek placement of the person at the forensic facility, the panel shall consider the following criteria. First, in subdivision 1, we have a list of clinical factors, including that the person is served in the least restrictive setting necessary to meet the needs of the person. And in subdivision B, the person's treatment and programming needs dictate that the treatment or programming be provided at an intensive residential level. And they're also considering dangerousness factors, including whether the person has inflicted or attempted to inflict serious bodily injury on another, attempted suicide or serious injury, or committed an act that would constitute sexual or lewd and lascivious conduct with a child, and there is reasonable probability that the conduct will be repeated if admission to a forensic facility is not ordered. They're also looking at whether the person has threatened to inflict serious bodily injury to the person or others, and there's reasonable probability that the conduct will occur if admission to the facility is not ordered. A facility is not ordered. They're looking at whether the results of any applicable evidence-based violence risk assessment tool indicates that the person's behavior is deemed a significant risk to others. The position of the parties to the criminal case as well as that of the victim, and any other factors that the panel deems appropriate.
Right?
I don't have a problem with the language, but I have a question about like the specificity of page 4, line 16 and line 19. Like, I'm wondering why we say dangerousness factors versus like safety or risk or whatever. I'm not trying to overly wordsmith, but that's my first question. Like, why I haven't seen dangerousness used like that before.
Yeah.
And then the second thing is, I understand why if a person has inflicted or attempted to inflict serious bodily injury or attempted suicide or serious self-injury or committed an act that would constitute sexual or lewd or lascivious conduct with a child, but I'm wondering why only a child? Because there's vulnerable adults and elders and people with disabilities who also, if something happens, we would have to make a report as a mandated reporter. So why would it only be with a child? I do think we should protect the children. I'm just saying, why so specific to children? And is that an area where we might want to like include other vulnerable people? And then the other thing is property, that in the duty to warn case in Vermont, a barn was burned down. And I guess one could say that could potentially inflict bodily injury, but there's nothing here about like that kind of level. Yeah, so just putting it out there. I'm not trying to make it more complicated, but I'm just doing like my due diligence.
Well, and now's the time that if we want
Okay.
to make language recommendations, we do
Okay.
that. So
I'd like the idea of adding it, or vulnerable people. Is that a defined term?
It's funny you should say that, because I was just downstairs all morning looking at the definition of vulnerable adults in the APS statute. So, you know, that the APS statute definition wouldn't apply here. But we could talk about, you know, if you wanted to do a cross-reference, it's a very specific statute, it's very specific language to pick up a certain population. But yes, that same question came up in human services, like why are we only talking about children? And as for the dangerousness, I don't think there's any magic in that word. That is the way the proposed language came to me from DMH. And I suspect that language around like risk or public safety, something like that, would probably be an appropriate replacement.
If that's what they asked for though, and I don't need to change it, I just wonder.
okay, so I have those two things flagged, so let's keep going and we'll come back.
We can get their feedback on that.
Okay. So now we're moving into Title 18, which is the health title. And we're adding a definition of forensic facility, which will need to be amended in light of human services change. So right now, we have that a forensic facility means a residential facility licensed as a therapeutic community residence for an individual initially committed pursuant to 13 VSA 4822, which refers to insanity for at the time of the crime or incompetent to stand trial for the mental health population, for individuals who are in need of treatment or further treatment pursuant to the chapter, and need programming treatment within a secure setting for an extended period of time. And then we were going to be striking out subdivision 2, which is the parallel language for individuals with intellectual disability. And then we have language that a forensic facility shall not be used for any purposes other than those provided in this chapter. And we also have a cross-reference the term secure, which would have the same meaning as secure in relation to what is securement when we talk about a secure residential recovery facility. So we're cross-referencing that definition here.
Can you share a high level?
Yeah, we're going to get to the definition itself. Do you want me to skip ahead and?
No.
Okay. Okay. So if you remember our chart from yesterday, this is the application for involuntary treatment. So this has already been somebody coming into the system. They've had an initial assessment, an emergency exam, and here is our application. This is the commissioner saying, we think that this person meets the statutory criteria for involuntary care. We're going to see if a judge agrees with us, so we have the ability to hold the person for involuntary treatment. So we have a lot of language in existing law. D has what has to be in the application. We sort of touched upon all those pieces yesterday. In subsection E, we have language, let's see, that the application shall be accompanied by a certificate by a licensed physician, which shall be executed under penalty of perjury, stating that the licensed physician, so we're using gender neutral language. And then we have the same thing in F, referring to the examining physician versus he or she. And then our new substantive language is in subsection G. So if the commissioner seeks to have a person receive treatment in a forensic facility pursuant to an order of non-hospitalization, the application for an order authorizing treatment shall expressly state that such treatment is being sought. The application shall contain, in addition to statements required in this subsection, that was the list in D, a statement setting forth the reasons for the commissioner's determination that clinically appropriate treatment for the person's condition can be provided safely only in a forensic facility, including the recommendation of the panel. So this language sort of mirrors language with regard to the secure residential recovery facility, that if it is the commissioner's intent to have a person treated in the forensic facility, they have to state that before they go to the court. They have to specify where this treatment is being sought, why it's being sought, why it's appropriate, and what the panel's recommendation on that point.
And this is the original language. It's not what was added by judiciary.
The only change from judiciary is the highlighted language. Yeah, so the G otherwise came over from the Senate. Okay, so section 6, we have submitted our application, and now we're at the point where the court is going to have a hearing on the application. So we have some existing language on the hearing. And then we have this new subdivision 3A. The applicant or a person for whom an order of non-hospitalization at a forensic facility is sought may file a motion to expedite the hearing. The motion shall be supported by an affidavit, and the court shall grant the motion if the court finds the person demonstrates a significant risk of causing the person or others serious bodily injury as defined, even while in custody, and clinical interventions have failed to address the risk of harm to the person or others. So it's a shall. Or the court may grant the motion. So some discretion if it finds that the person has received involuntary medication in the past 2 years, and based upon the person's response to previous and ongoing treatment, there's good cause to believe that additional time will not result in the person establishing a therapeutic relationship with providers or regaining competence. If the court grants the motion for an expedited hearing pursuant to this subdivision, the hearing shall be held within 3 days from the date of the order expediting the hearing, and the court may grant an extension of not more than 5 days to allow for psychiatric exam. So I will say that this language parallels or mirrors existing language on an option for expedited hearing to go to a hospital. And now we're mirroring that for to go to the forensic facility.
Leslie and then Daisy.
So this is the first time I'm thinking about the contrast between a forensic facility and a hospital. So so this is not, the forensic facility is a non-hospital placement. So that's sort of putting my head around that. But what support services are available to this individual at a forensic facility? What can we, and you may not know that. Clearly, I get that.
That's a department question.
Yeah.
There is a report that we'll look at the end. There was Health and Welfare added a report to sort of ask for information about what the programming and treatment will look like, what will the staffing look like. But, perhaps you'd like to supplement that, or, depending on what you hear from the department.
But we need to, I would imagine that there'll be medication involved or whatever, so.
So just remember, so I'm trying to get DMH on here,
Totally.
but remember, we have heard from them. A lot of these questions were answered.
Okay, well, maybe so. Sorry.
Okay. So I will keep moving. Our next section, I'm sorry.
Oh, I'm sorry, Daisy.
And let's see, page 9, line 19 in little I, it starts, that section refers to clinical interventions that have failed to address the risk of harm to the person or others. Is there a period of time associated with the failure of clinical interventions?
Not in the language.
Where do you see this again? I'm sorry.
Little I on page 9 at the very bottom there, line 19. I think there was 2 years mentioned in another section.
What was the question?
So the question is around the period of time at which it has to be demonstrated that clinical interventions have failed to address the risk of harm to the person or others.
The 2 years is, the court may grant the motion if there was involuntary medication in the past 2 years. So that is different. That's different, yeah. So this doesn't have a time frame, and the one in existing expedited process for hospitals, it doesn't either, because this parallels it.
So we'll flag that. Okay.
Section 7. So at the court, we've had our application, the court has had its hearing, and then the court makes an order. So we have just some headings added to sort of clarify where we are. So in A, we have the order of non-hospitalization. In A1, we have language that if the court finds it's appropriate, the court can order an order of non-hospitalization for an order of 90 days. That applies to everybody who is under an order of non-hospitalization. That's not specific to the forensic facility, although it applies to the forensic facility. And then in A2, we have if the commissioner determines that treatment at a forensic facility is appropriate and the court finds that treatment at a forensic facility is the least restrictive setting adequate to meet the person's needs, the court shall order the person to receive treatment there for a period of 90 days. The court may at any time on its own motion or on a motion of an interested party review the need for treatment at a forensic facility. So it makes its initial order and then the court can review at a later date. Yep.
Okay, when the term least restrictive is used, I'm trying to, in my mind, understand how a forensic unit that's locked is the least restrictive.
So it may be that other options where without a locked facility, for example, don't meet the person's needs. The person is at a high risk of maybe escaping into the community and potentially hurting themselves or hurting somebody else.
So the least restrictive place could in fact be the most restrictive in that person's case.
Well, what might be the least, I don't know how to say this, what might be the least restrictive to meet the person's needs might actually be quite restrictive, but that is the level that they need to meet their needs. And that language, as you probably have noticed, you've seen it a couple times in the bill now. There's a U.S. Supreme Court case, the Olmstead case, that requires that people be treated in the least restrictive setting to meet their needs. So that's why that is built in over and over again to the standard.
Melissa and then Brian.
Actually, I'm sorry, I'm gonna pass.
Brian?
I was just gonna comment that if you know, I think for many people who would end up in a forensic facility, it's like the least restrictive settings that they could probably be kept in to be safe would be like jail or the forensic facility. And so like in that context, I feel like this really is improving what we can offer someone when they're in a bad place.
In 2, if the commissioner determines that treatment at a facility is appropriate, is it the commissioner that determines it or is it the community safety panel?
The safety panel is only making a recommendation to the commissioner.
Okay.
So the commissioner is ultimately responsible for making the decision whether or not to apply for commitment at the forensic facility.
And is there language, it's looking at section 2 again, to file for an extension so that if it's deemed that the person would benefit from staying longer than 90 days?
So the initial order is 90 days, and then if it's determined as that 90 days is about to run out, that the person needs more treatment, then they, being the commissioner, files an application for continued treatment, and that can be for up to a year. And then they could file for another one and another one. So
At the AIT?
so the AIT is the application for involuntary treatment. That's the 90 days. ACT, application for continued treatment, is for up to a year. AM is our application for involuntary medication.
And that's what we reviewed yesterday. That same process applies here. Okay.
Okay, so we're on subsection B. Added the heading non-compliance with an order or inadequacy of treatment. This is existing law that we sort of skipped over quickly yesterday that says if the court finds that the person is not complying with an order of non-hospitalization, I mean, really, this is specifically for people in the community who maybe aren't, taking a required medicine or showing up for appointments or things like that. And the court can reconsider its order and maybe make adjustments to it. Or if it's found that the person's on order of non-hospitalization and it's not adequate to meet the person's needs, this gives the court permission to amend its order.
I'm gonna, sorry, Katie, Alyssa and then Art.
Yeah, I'm sorry, I keep getting hung up on this. So we're talking about a forensic facility here. You know, we're not talking about like what we were talking about yesterday. But and I understand the need to put the least restrictive to meet that person's needs, but have we lost in here public safety? Or does what we were talking about earlier on regarding public safety, does that cover this?
So the panel is making a recommendation, and that recommendation is taking in, remember, we looked at, there was the question, is dangerousness the right word? But we were looking at the person's violence assessment, the risk assessment tool, the crime that they committed. I could pull the list back up, but those different factors were being considered by the panel. The panel's recommendation informs whether the commissioner seeks the placement of the person in the forensic facility.
But then once it's been deemed by the court that they will be in a forensic facility, it seems like this language, all of that other consideration drops and it just becomes what is best for the individual. Am I reading that right?
You mean this language where they're making the order?
Yeah.
I mean, what is the court looking at? First, we have the commissioner is determining the appropriate setting, or if this is clinically appropriate. And then we have the court saying, is this least restrictive in line with Olmsted? The court isn't looking at, is this person potentially, it's not looking at the person's, I don't know what the right word is, level of dangerousness. That's not part of the standard here. That's been built into whether the commissioner is asking for this placement in the first place.
The whole next section too is about the public, so maybe when we go there, you'll see, like the whole thing about discharge that's coming up is all about victim and the public, so.
Okay, Art.
Alyssa and I were thinking exactly on the same wavelength. I was thinking if it meets the person's needs, you could put in the public safety. I don't know, maybe it doesn't belong there, I don't know, but
So let's flag it.
I'm more
Flag it.
concerned about that than
Melanie?
person's needs, quite frankly.
I looked back at our notes, or my notes from the other day when we heard about this, and where I was wondering if maybe the least restrictive piece inside of forensics, because I asked about what is different about a forensics facility, and they said it's physically locked, it has a fence. Within the programming, there can be staff hands-on, restraint, seclusion. So it seems like there's a menu of things, but like the thing that I remember being said is it is locked, it is a fence, it's different than that. And then in addition to that, there are a whole spectrum of care, psychiatry, counseling, so that was in addition to it. So I wonder if that is playing into what is the least restrictive in that setting, like the non-negotiable is locked, fenced in area, but then in that, maybe someone has to go to seclusion, someone else has to be restrained. I'm not sure if maybe that's the.
And we're having DMH come.
Yeah.
So we need to get through the language so we can ask them all our questions. Daisy?
How does it come to the court's attention? I'm on little b, the pink part, when there's non-compliance with an order. How does it come to the court's attention?
I'm not sure. I think that's a better question for clinicians. It's not specified here in the statutory language. And this is not a proposed change. This is existing law. So probably it's happening in practice and there's clinicians with experience.
Yeah.
Okay, so now we're moving to discharging the person from the forensic facility. When a person has been committed to the forensic facility, the commissioner is to provide notice at least 10 days prior to discharging that person from the forensic facility. The notice goes to either the state's attorney of the county where the prosecution originated or to the AG's office if that office originally prosecuted the case. Excuse me. When either the state's attorney or AG's office receives that notification, the respective office is to provide notice of the discharge to the victim, any victim of the offense for which the person was charged, unless the victim has opted not to receive notice. So that's a possibility that the victim could say, I don't want notice if there's a discharge. And then we have a cross-reference to our definition of victim. The state's attorney of the county where the prosecution originated, or the AG, if that office prosecuted the case, or the victim, may request a discharge hearing to be held within 10 days after receiving the notice under the hearing. So after this discharge notice has been given, either of the two prosecuting officers, whichever one prosecuted the case, could ask for a hearing, or the victim could ask for a hearing on the discharge within 10 days of receiving notice. The discharge would be stayed during this period. So the person wouldn't be released while this hearing is pending. And then we have whichever office did the prosecution and the victim could be permitted to appear and be heard on whether the person shall be discharged from a forensic facility. The prosecutor can call witnesses and present evidence. But this is important. When deciding whether to discharge a person from the forensic facility, it's the commissioner shall have the sole discretion to take testimony or evidence provided pursuant to the subdivision into consideration. So this isn't a hearing where a court is weighing this evidence. Ultimately, it's the commissioner that is hearing the evidence and is saying, yes, I'm going to take this into account and maybe not discharge the person. It's not a court that's taking that testimony into account. For persons that are committed to the forensic facility, the criminal division of the Superior Court shall retain jurisdiction over the person's underlying charge, and any orders concerning conditions of release or bail shall remain in place. The orders shall be placed on hold while the person is held at the forensic facility, and when a person is discharged from the forensic facility to a correctional facility, the custody of the Commissioner of Mental Health shall cease upon the person entering the correctional facility. So this is saying, this is sort of particularly for the situation when the person is not competent to stand trial, but their case hasn't been adjudicated. So they're at the forensic facility. If at some point in the future, the person regains competence and they're going to be tried, this is saying that the person's charges are still there. They still have to be adjudicated, and that when they leave the forensic facility and go back to a correctional facility, they're no longer in the custody of the Commissioner of Mental Health. They're now in the custody of the Commissioner of Corrections. All right.
Page 13, the first paragraph, if you could repeat that. I'm having trouble understanding
That last.
Especially if we had this four-person panel in the initiation of the process, why would it be only the commissioner that has the discretion to take testimony or evidence provided? So that's a question for.
Policy question.
Yeah, but can you just review that again so I'm sure I understand?
Okay, so we've already had notice. The commissioner has provided notice of an intent to discharge within 10 days. The notice goes to whoever the prosecutor was, either the Office of the Attorney General or the state's attorney in the county where the case was prosecuted. Once that notice is given to the prosecutor gives notice to the victim of the discharge if the victim hasn't opted out. At that point, either the prosecutor or the victim can request a hearing. And at that hearing, we have a list of all the things that can happen. The prosecutor or the victim can provide testimony, they can offer evidence, but they're offering that evidence and testimony really to the commissioner, because the last sentence is saying that it's solely in the commissioner's discretion whether to take into consideration that information that's being presented.
Right, I'd like more discussion on that I see potential problems there. And is it a statutory requirement that the notice of discharge be given?
Under this, yes, as written.
In current law?
Oh, in current law? I'm not sure about that piece. That's a
may
question.
or may not have record accurate records that notice of discharges were faithfully given.
I'm not certain. I'm trying to think if I've seen it in Title 18 before. I know we've definitely talked about it in S3, and I don't remember what passed in S3. So can I get back to you?
Absolutely.
Okay.
Because that might be something, if there isn't a statutory requirement or some sort of reporting that goes on so that we have good data, I might want to add that.
Okay, let me write myself that up, but I will
Thank you.
remind myself what we passed in S3.
So just so I understand, it's back to that public safety piece. So people came into this through the criminal justice and they either were competent, they were not competent to stand trial. So if they are now competent, they are in the correction still and they are maybe going to court again and doing this one way.
Potentially.
But then if they were in here because they were found not guilty by reason of insanity, when they get just discharged, now it's the commissioner and the teams that are saying they are no longer a threat to the community and they just discharge them into the community? Is that the two pathways where people go?
Yes and no. The first was yes, if the person regains competency and the prosecutor still wants to move forward and the charges are still there, potentially the person will be adjudicated and they may be in a correctional setting, transfer back to a correctional setting. If the person was not guilty, it was adjudicated not guilty, it would be a clinical decision whether or not the person should continue to be held at the forensic facility. If at some point the clinicians at the forensic facility and the commissioner are saying this person no longer needs this level of care, one option, I suppose, would be to have the person in the community. Likely with this population, that's probably a less likely option. It would probably be an order for continued treatment in a less restrictive setting.
Great.
But, you know, the DMH would be in a better position to give you more specifics about how that would work.
You have a question, Jeff?
Yeah, just, it's more of a, could you go up
Yeah.
on the document? 13, verse 13, top of it.
Page 13?
Oh,
Page 13.
right here?
Yeah, right there. The commissioner of shall, does the of belong in there? Line 3?
Nope. I should have said of mental health, but we didn't need mental health, so I struck mental health but not of. And also,
I saw it and I figured I pointed out.
and I think a question also came up on line 1, when deciding, no, not there. On line 9, when a person is discharged from a forensic facility to a correctional facility, the custody of the Commissioner of Mental Health shall cease upon entering the correctional facility. I think somebody said, could it be if the person is discharged from the forensic facility to the correctional facility, to account for the fact they may not go to a correctional facility, they might be in a different, less restrictive setting. So flagging for the future. Okay, so that was our initial 90-day order. Section 8 addresses our application for continued treatment. So this is the 90-day order is about to expire. The commissioner feels that the person should still be committed and receive further treatment. So this is an existing process that's set out in statute. And we don't have a whole bunch of new underlined language because there's already a very similar process in place for the secure residential recovery facility under an application for continued treatment. So we've just sort of borrowed the language that's already in statute. If the commissioner seeks to have the patient receive further treatment in a forensic facility or a secure residential recovery facility, the application for an order authorizing continued treatment shall expressly state that such treatment is being sought. The application shall contain, in addition to the statements required in B, a statement setting forth the reasons why the commissioner's determination that clinically appropriate treatment for the patient's condition shall be provided safely only in a secure residential recovery facility or forensic facility as appropriate. So we're just building off that existing language. And then there was a question previously, what is the definition of secure? So here's the definition that we cross-referenced earlier. When describing a residential facility, means that the resident can be physically prevented from leaving the facility by means of locking devices or other mechanical or physical mechanisms. Okay, section 9. So we've submitted our application for continued treatment, and then there is language on the hearing for the continued treatment. Again, we already had a process and we already do have a process in place for the secure residential recovery facility. So just like we did in the last section, we're building off of that. We're borrowing that language and just adding secure forensic facility where we're talking about the secure residential recovery facility. So if the court finds that a patient is a patient in need of further treatment but does not require hospitalization, it shall order non-hospitalization for up to 1 year. A treatment plan proposed by the commissioner for a patient in need of further treatment, if the treatment plan includes admission to a secure residential recovery facility or a forensic facility, the court may at any time, on its own motion or motion of an interested party, review the need for treatment at the secure residential recovery facility or forensic facility as applicable. So now we're sort of pivoting a little bit. So far we've only been looking at how to treat a person, how to hold a person in the forensic facility. So it's more of like a custody decision up to this point. So now in section 10, we're looking at an application for involuntary medication. So this is a separate application, a separate process. This list that you're going to look at, do you remember the picture I showed you yesterday with the 6 columns? So here's the list. Each of these conditions was a column, and this adds a new column. I renumbered 7, so just so you know, now we have 7, but it appears in 6. So a person can receive involuntary medication, or the commissioner can at least apply if the person has been placed under an order of non-hospitalization at a forensic facility or has an application for involuntary treatment at a forensic facility pending, for which the court has granted a motion to expedite pursuant to that cross-reference, regardless of whether the person has previously been under an order of hospitalization. So that is the circumstance in which the court could seek, or really 2 circumstances in which the court could seek involuntary medication for a person, either who is already at the forensic facility or who there's an application pending for the person to be at a forensic facility and it's been expedited. Some conforming language changes. And then after the court receives that application, it has to have a hearing and make findings on that. And so we have a new subdivision O for a person who is receiving treatment pursuant to an order of non-hospitalization at a forensic facility. If the court finds that without an order for involuntary medication, there's a substantial probability that the person would continue to refuse medication and as a result would pose a danger of harm to self or others, the court may order administration of involuntary medications at a forensic facility for up to 90 days unless the court finds that an order is necessary for a longer period of time. An order for involuntary medication pursuant to this subsection shall not be longer than the duration of the current order of non-hospitalization. If at any time the treating psychiatrist finds that the person subject to the order for involuntary medication has become competent, the order shall no longer be in effect. So that mirrors a lot of the same language that's in place for a hospital setting. Then we move into the intellectual disability language, so I'm going to move over that. I know, you've cut out half the bill now. Okay, and here is the language on a certificate of need. So,
We're on section 20, just.
Thank you,
Page
yes.
29.
So 9435 talks about exclusions to having to obtain a certificate of need. And we're adding a new subsection G that excluded from this subchapter as any forensic facility as defined by our cross-reference that is supervised and operated by the Commissioner of Mental Health or the Commissioner of Dale or both. So that would be amended, but the idea is that to build a forensic facility, to repurpose and create a new, I don't want to say facility because we're not necessarily talking about bricks and mortar, but to set up a new program for a forensic facility, there doesn't need to be a certificate of need.
This is definitely a policy decision for us. We have Karen over here, so as soon as we get done the language, we'll switch to her and ask all the questions, and this will be one of them. And then I'll talk to Susan offline.
Okay, we're removing the rulemaking section. I mentioned this at the beginning. This was about admissions criteria, so instead that's sort of embedded now into this draft. We do have conforming amendments. So this is directing that rulemaking shall initiate on or before July 1 of 2023. We know it won't be completed by then, 'cause it's a long process. That's why we're setting a date for initiation. And this directs Dale to amend its therapeutic community residence rules to allow the use of emergency and voluntary procedures.
So I'm going to stop. So is this just for Dale?
No,
Okay.
this is applicable to you. So
Okay.
because Dale licenses the therapeutic community residents, they have the rules for therapeutic community residents. This forensic facility would be licensed as a therapeutic community residence. So this authorizes the use of emergency and voluntary procedures and involuntary medication at a forensic facility. And this tells Dale to amend their rules to make it so.
Okay.
And then Dale has, DMH also has to amend one of their rules for the purpose of allowing the administration of involuntary medication at a forensic facility. And then we have some language that Senate Health and Welfare added. So we have by February 1st of next year, the departments presenting to the various policy committees a plan for staffing and programming at the forensic facility, including whether any specialized training will be required for staff members and whether any services provided at the forensic facility will be contracted to third parties. A plan for the joint management of the forensic facility, which, that will be struck. Whether any additional resources are needed for the operation of the forensic facility. And then there is a report annually on or before January 15th between the years of 2025 and 2030. The departments are submitting a report on the average daily census at the forensic facility, including trends over time, the number of individuals waitlisted at a forensic facility, and where these individuals receive treatment or programming while waiting for a bed at the forensic facility, aggregated demographic data about the individuals served at the facility, an account of the number and types of emergency and voluntary procedures used at the facility. And then, so this really takes effect July 1, 2024, with the exception that rulemaking would start ahead.
And so, Mari, I'm wondering if in that study, if there's language you want to offer to meet your question about discharge, public discharge notice.
Yeah,
Okay.
that'd be great.
Thank you, Katie.
Welcome.
I think what I'm going to do, since we asked Karen from the Department of Mental Health to join us, I'm going to switch to her and not allow any questions just yet for Katie. And kind of go back through some of the questions that we wrote down. Karen, are you there?
I am, yes. Good morning.
Good morning.
My apologies. I am in the car, so I don't have video, so apologies.
No worries, and I appreciate you coming. I know you just finished testimony somewhere else. So we have a couple of questions. I'm going to start with the first one, which is you're asking for no certificate of need for this forensic facility or any potential forensic facility. Can you explain why?
Sure, happy to. I will just wonder if I can make one comment before, just is that it does seem as though you're thinking along the lines of taking the developmental disabilities section out. I'd just like to really strongly urge you all not to do that. This is jointly a DMH and Dale project. We worked really hard and designed everything to be done together because the gap in the system is both, right? DMH alone cannot fix the gap in the system. Not only do people not meet hospitalization criteria that we're talking about, but we're also talking about people that wouldn't go into our system anyway. And if you take away the ability for some people to use this facility, you're really, I think, doing a disservice to Vermonters. So I just wanted to kind of say that our position really has strongly been that we think they both need to be done together.
Thanks, Karen.
Yes. As to your specific question about CON, sure. So The certificate of need process is the public process, right? It is for when new facilities or new programs are being built. It's the way for the public to hear about them, to get information about them, to be able to testify about them. That process is playing out in the legislature. That's what you're doing now. So we don't also need to do it there, right? It's a lot of time and effort to do the same thing that you guys are already doing. And if the legislature says we have to do this, then the Green Mountain Care Board can't overrule that, right? We did do it for Middlesex, for the new River Valley, and that's what we realized, right? Everyone was kind of like, what are we doing here? You guys already went through this in the legislature. The legislature has already said this is what you must do. That's very different than a facility that has no legislative oversight or no program that doesn't have any legislative oversight, right? Like a hospital that's wanting to build something. So from our perspective, it doesn't make sense. You guys are already doing the CON.
But you're asking, and so I just want to be clear with the language as I read it, you're asking for, since this is potentially a initial forensic facility, you're suggesting that we wouldn't need a CON for any future additional forensic facility as well.
Yes, because again, I think the same thing is you've already gone through the process and determined whether that if it passes, right, you've made the determination that the state does need a forensic facility, and we've set the parameters and the due process around that. If we are going to need money to build it, then it's going to come back in front of you, right? And so then you would do all those money pieces. There's no way we would be able to do it unless you guys weighed in and already did that work. So again, we don't think it's necessary because you guys would already be doing that work. Does that make sense?
It does. Daisy, and then, I mean, we may not agree with it, but it makes sense what you're saying.
Correct me if I'm wrong. I don't think we're doing what she said we're doing. We're not having witnesses in here talking about whether they think it's good. And we're not doing that.
Daisy?
And similarly, I think previously when we talked about, the public process, or maybe Karen, it was in corrections and institutions, you referenced the rulemaking process as being a way to get at that public input. And now that the rulemaking process is, in the version I'm referring to, is struck, and I don't recall who took that out, whether it was judiciary or at the recommendation of AHS, but with that taken out, I'm also questioning the amount of public input, just putting that out there.
Okay. Brian?
I would, oh, sorry.
That's it. Hold on, Karen. Let me get the comments out from the committee and then we'll go back to you.
I see your point about not wanting to create duplicative processes or waste resources, but I guess I don't know if they're exactly duplicative, partially because of the opportunities for public comment that the Green Mountain Board has that we don't have. Like, people don't show up here every day and get 20 minutes to just weigh in and stuff like that. And also, and we have Green Mountain Care Board here, so they could always correct me, but my understanding is they look at the entire system and at the financing of the entire healthcare system, and they're looking at a need for service as well as the economics of it in a way that we may not get into. But I'm not saying that we necessarily need to have the certificate. We need the certificate of need if we were able to take a few extra steps now, but I don't know if we've adequately done that.
Okay. Art?
I'm not clear what a certificate of need exactly is, and I would love to see that. I mean, probably somebody could show it to me, what it is, what it consists of. I'd like to know that first.
Melanie?
And it was my understanding that this kind of forensics facility is serving a small part of our population. So I would be concerned if we were building lots of these without a public discourse and being able to say what's failing if we need so many of these. So that's just my 2 cents. Maybe I don't understand what a certificate of need is either, but I would, if we need to build more than just this one, it's not a the and an A. I find it concerned about that.
Okay, Daisy?
I would just say that kind of add on to my previous comment that, you know, I think the need for this isn't a moment in time and like right now, and I'm not concerned about a lack of having a line of public witnesses to testify on the need for this, because I think it's very simple to look at the years of testimony that we've had across this body. I know it's very easy to lift that up. And I certainly have looked at that. So it's not like we haven't had testimony on the need for this. We haven't had it in this, on this specific bill, but I certainly have seen it.
We had it in S3 last session.
Yes, and I definitely listened to that. So I'm convinced of the need. So just wanted to say that.
All right.
I agree about the certificate of need process involving the public or there's more of an invitation to participate publicly. There's an opportunity to file to be an interested party. I also believe that there's a need for this facility. We need to have the capacity that we don't have right now. I don't think that we should set into statute that legislative process replaces the certificate of need process. I'm not comfortable with that, but I would feel comfortable making an exception in this instance. And if the committee chooses to require in this instance that there is a certificate of need process, I can point out, and Green Mountain Care Board can talk further about this if they wish, but there is an expedited process for certificate of need.
Listen.
I just wanted to, I guess, weigh in on certificate of need. So first of all, Green Mountain Care Board certificate of need process is intended to prevent unnecessary duplication of healthcare facilities and services, guide their establishment in order to best serve the public, promote cost containment, ensure provision and equitable allocation of high quality healthcare resources. We're talking about a forensic facility here. We're not talking about a new surgical center or a new birthing center or anything. I mean,
5 MRIs.
We're not trying to promote cost containment. We're not mucking with our healthcare system. We're providing a facility that we're in need of. And if the legislature deems that we're in need of it, I don't see why we would even contemplate having a certificate of need process.
Okay, so we're gonna table this for now, so that since we have Karen, so good conversation. So Karen, back to the bill, which I know you're in the car. So in section 4, where we talk about, that section 4, page 4, sorry, hold on. Page 4, row 16. So in the section of the bill where we're talking about the notice of the hearing and procedures, there is a section where the panel, the Human Services Community Safety Panel, is considering the following criteria on whether or not to seek placement of a person in a forensic facility. And number 1 is clinical factors. Number 2, the word dangerousness is used, and we were wondering why that word and not our normal kind of standard language where we use like, at risk to a danger to themselves or others.
So that's a great question. I think part of what we were attempting to do when we were listening to various stakeholders was that there is a concern that public safety needs to be also taken into consideration, maybe a little more so than it is now. And also that the goal of this is, again, to make it a very limited population. And so kind of that aspect of it was one of the things that would allow us to kind of meet the burden that both commissioners have to serve people in the least restrictive setting possible. Because this would be a very restrictive setting, there needed to be evidence that serving someone in the community in this instance would not be appropriate, kind of given their level of not just acuity, but also some of the public safety issues.
So could we just say public safety factors?
Sure. Yeah, I think that's fine.
Okay, so you're open to language change. We'll look at that as a committee. Okay, and then in that same section, so one of the first factor is whether the person has inflicted or attempted to inflict serious bodily injury on another, attempted suicide, blah, 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 or committed an act that would constitute sexual or lewd and lascivious conduct with a child. Why not everyone there? Why just a child?
Where are we?
We're on page 4 on row 18.
Gotcha. Thank you.
That is an excellent question, and one I'm not sure. That was probably just an oversight. I know what we were doing is we were looking at other states as kind of models and borrowing some language. So we're certainly not tied to that language if you all have changes you'd make to that.
Okay, great. And then Daisy, you had a question about time frame, and I did not write down where that was.
It's on page 9, row 19.
So which the section since Karen's driving?
I pulled over, so I have the notes.
Thank you, Karen.
Section 6.
What page? Sorry.
So page 9.
Okay.
Or 8 for the new version.
Oh, I'm in 3.1. Am I not in the right version?
Yeah, 3.1.
Right.
Okay, I'm on 3.1, page 9, row 19. Little I, shall grant the motion if it finds that the person demonstrates a significant risk of causing the person or others serious bodily injury, even while in custody, and clinical interventions have failed to address the risk of harm to the person or others. Is there a time frame for when those clinical interventions are determined to have failed?
No, because everyone is different, right? And so that requires, a doctor to testify to that if asked to do so. Because again, everyone's different. And so you can't really put a time frame on it because it also depends. Do you know the person? Have they been in the system before? Do you know how they react to certain things, or is it brand new? Often we'll file quicker on someone who we know versus someone we don't, where we're letting those relationships build. So it's really a clinical determination.
Your follow?
I'd like to hear from a clinician on that.
Karen, is this language that's taken from another process in our state that we're moving over from?
Started writing an amendment for another committee. So what section is it?
We're section 6, hearing on application for involuntary treatment, but we're adding language, row 19 on page 9.
Yeah, I think if you look up to like row 3, line 3 of page 9, it's the same language that already exists, right? Even while hospitalized and clinical interventions have failed to address, it is what we do now. We're just doing it in the forensic facility versus in a hospital, but the language is the same, right? And again, we have the burden to show that in the court. If the court has concerns that we haven't proven that, then the court can say that and require us to put a doctor on, right? But that we haven't created any new language. We're borrowing the same programs. The idea is to offer them the same due process they get now. It's just a different facility.
Right, and I'm not even aware of what happens now. I'm just noting that every other procedure in here, which is around filing a motion to expedite a hearing, has a time frame on it, except this one. And especially, I mean, to me, it just doesn't specify when something can be determined to have failed. So I appreciate that everybody's different. Trust me, if anybody appreciates that, it's me.
Yeah. No, but it is consistent with the language, right? It is consistent with the line 3, right?
I understand.
Okay, so it's already.
All right, so we'll come back to that.
Chair, before you go further.
Yeah.
I brought up something in the
Yes,
beginning.
you did. I'm getting there. The panel?
Yeah.
I'm getting there. So, because I want to do the panel all stuff together. So we have a couple questions on the panel. So the first question is, the panel consists, and I know this is language put in from judiciary. The panel consists of the Secretary of Human Services, the Commissioner of Mental Health, Commissioner of Dale, which may come out, and the Commissioner of Corrections. And then it says the panel should have the technical, legal, fiscal, and administrative support. Nowhere in here does it mention medical support and the medical analysis that needs to be done to determine, as part of the criteria.
Or clinical.
Or clinical, probably is a better word.
So, oh, sorry.
No, go ahead.
Okay. Yep. So that's a great question. So our staff, so we have clinicians on our staff, right? So DMH, by statute, our commissioner has to be licensed, right? So, and this is really just solidifying a process that already happens now. So right now in DMH, once we get an evaluation that shows someone as not competent or insane, we come together as a group. So that includes our medical director, who is a psychiatrist. That includes our commissioner, who again is licensed. That includes our care management team. They are all are licensed. And then our director of, hey girls. Sorry. Yeah, so there's a bunch of clinical people already on the team that are looking at these. So you could add the word clinical. It does already exist. But certainly, we have our licensed folks in addition to our legal folks, right? Because it's clinical and legal looking at all of these.
Thanks, Karen. I think we're going to add clinical, Katie, to that section. Thank you. And then Mari had a question about why is the panel, Mari, you have
So in the section around, I think it's around discharge.
page 13.
It says that only the commissioner of DMH can, I don't have the language pulled up, can accept the.
You want me to help?
Yeah, thank you.
Karen, this is Katie. The language we were talking about on Monday, where there's the discharge and the prosecuting office and the victim can ask for a hearing and they can present evidence and present testimony, and then we added that sentence. But it's ultimately the sole discretion of the commissioner whether to consider that evidence and testimony and determining if discharge is appropriate.
And my concern there should be more conversation around the discharge process, and if the initiation of hospitalization, but admission to the forensic facility involves a broader group, whatever that panel is called, for discharge, why not have a more robust process as well, including determining whether or not to use specific information to make the decision about discharge.
Sure, I'm happy to talk. Sorry.
Go ahead. Karen.
Sure. Okay, I'm happy to talk to that. So why is this so important? So 18 VSA 7616 is one of the foundations of the mental health system, and it makes it clear that we have the authority to dismiss the application at any stage of the proceeding. So this is existing law, right? And the reason it's so important that the commissioner has the ultimate determination is because we have the burden. That same statutory section says the state shall have the burden of proving its case by clear and convincing evidence. So when we discharge someone, it's because we can no longer meet our burden, and that's our burden, right? It's our liability, it's our responsibility, not just by Vermont statute, but also ADA and the Olmstead puts that on the custodial commissioner, right? And so the reason that ultimately it is our decision is because it's the commissioner that has to meet the burden. If she can't meet the burden, her obligation is to discharge. these don't exist now in Title 18, right? Because again, the statute's already clear. The policy on this is clear. What this is doing is what we heard from victims and state's attorneys is that there's a concern that there's a lack of transparency about this process. And there is a lack of transparency, right? Because these are family court hearings. These are about protected health information. So not just under HIPAA, but there's actually a specific Vermont statute that says all of these proceedings are confidential. So this is, again, for this very limited, narrow population, adding a little more transparency. So what it's doing is it's adding some notice so that people know what's happening. It's giving victims the right to be heard. No, it doesn't ultimately change necessarily, although it's possible that the state's attorney could say, hey, here's some things that you should consider, and I actually do think you could meet your burden. So that's kind of why we designed the process that way. You could have it go through the panel, but again, ultimately it's a custodial commissioner decision. But certainly we're always taking all of that into consideration. These are not done lightly. Does that help?
Yeah, I still have concerns, but I hear what you're saying.
And I just want to throw out there, I think some of our concerns are about a process that kind of already happens. And I'm going to put out there that I think we need to we need to factor that into our decision-making on this. And then we also need to realize there might be some bigger issues that we tackle next year. And that this is about the forensic facility. So I just want to put that out there because this is the first time for our committee really hearing what all these processes are. So I recognize that it's a little hard for us to do this, having like it's all being piled up at once. So Daisy,
Karen, if folks with intellectual and developmental disabilities can not be served in this facility, can it still be licensed as a therapeutic community residence?
Yeah, River Valley and Middlesex are TCRs. Yep.
all right, it is noon, but we have Karen, so I want to give her time back. Also want to make sure that if there's any like immediate questions that I missed, in my writing.
I just want to get with Katie about
Katie
adding
and
that to
some
the
language.
report.
Yep, so we can do that. Pepper?
Maybe one.
Okay.
Katie, somewhere along, I think it was section 21, you mentioned that CMS had to give approval. But CMS had to do something in order for this thing to happen.
The IMD waiver,
Huh?
around the IMD waiver?
Yeah.
Oh.
I don't know exactly what she mentioned. But in here, section 21 is effective immediately on passage. And that's what sets it up. If CMS says no, what happens?
Okay, go ahead, Katie.
Just depending on the rulemaking. Yeah, so yes, the rulemaking takes effect right away. Just because they have rules in place doesn't necessarily mean that they have to have a forensic facility. They have to have rules and no forensic facility, I guess, in theory. So that doesn't really set us up for failure. But if you want to know more about the IMD, have you had Ashley Berliner? And
I'm okay on what it is and all that. What I'm concerned about is we go ahead and do this, and then CMS says no.
Right, so with the and Karen, why don't you answer this since you know the IMD waiver well? Talk to us about IMD Medicaid reimbursement for this facility or not. And then I promise we'll let you go.
No worries. Happy to answer all your questions. This is a very important bill, so we are thankful you're taking so much time on it. So IMD means Institutes of Mental Disease. It is an outdated term, but that is the term on the federal level. And basically what it is for any facility that just provides psychiatric care or substance abuse care over 16 beds is considered an Institute of Mental Disease or an IMD. Hospitals are a little different because when you're looking at, say, like a Rutland or a UVM, it's the percentage of beds that are psychiatric beds versus regular beds. So VPCH is an IMD, right? There's 25 beds. We do have a waiver, an 1115 waiver, it's called, that allows us some flexibility in terms of paying for those beds. We are kind of in phase down, which means they've made it clear to us that they're not going to continue to pay for the full 25 beds the way they have been. So we have, and I think we're still, I don't know, we're still kind of in some of it, but what we're looking at more is about the length of stay, trying to get some flexibility, less about the number of beds, but more about the length of stay. Can we keep the length of stay under 60 days? The federal government is also really clear that they don't pay for they call it the inmate exclusion. So that's another thing that you can't use Medicaid funding for. So we already, if someone has come in through the criminal court, we're already not using Medicaid funding to be able to pay for them because the federal government's pretty clear we can't use that. So these beds would be general fund beds because we couldn't use Medicaid for them. But again, we have folks that we're already doing that for. There's kind of two branches of CMS that oversee facilities. There's the funding piece, right, which is this IMD, and we're talking about the waiver and how do we get Medicaid match for or reimbursement for our beds. But then there's the licensing and protection end. So we are not so much concerned about the money piece, but licensing and protection under the CMS. So we have to, in order to get Medicaid funds, we have to be accredited by CMS. And we also have to be, joint, it's called the Joint Commission. They're a certification organization. So they do some of the work for CMS in terms of going out to facilities and making sure, clinical criteria is met, zoning criteria. So there's kind of two pieces of CMS. We're less worried about the money piece again, because we do know that we already can't use this money for those folks. We have had conversations with them about the licensing piece, and we do feel like there's a path forward for that. Does that help? It's kind of confusing because a lot of people talk about IMD, but what DMH is also really talking about is our licensing piece, because that's really key for us and able to kind of operate our facility.
And so if we might do rulemaking, but the federal government might come back and say, you don't have that. And so then this just goes away, right? No?
I don't know that they would. I don't think they would say you can't do it. What they may say is like, it may impact your funding in a way that, in a different way, and we'd have to have those conversations. I think Ashley Berliner, who is the head kind of negotiator with CMS, feels comfortable on the money piece. And then I think our commissioner has had some conversations with the kind of the accreditation piece of CMS, and also feels like there is a very solid path forward.
So if you feel that there's a very solid path forward, that's the reasoning that you're using to go forward with this thing. I would just ask one more question. Is there any doubt in your mind that the state is going to have to pick up the entire cost of that hospital if we do this?
So, it would be that, so the idea is that the 16 beds would remain hospital level of care beds, and that we would use Medicaid funding to pay for those beds, but that the 9-bed residential beds that were for this kind of forensic population, that they would be general fund, but that we would still continue keeping Medicaid for the hospital level of care folks.
Karen, I understand what it's perceived to be. What I'm concerned about is whether or not, if CMS says no, and we have this unit established, new people licensed and so on, and everything is taking place, and CMS says no, is it going to include the whole building?
The 16 beds, the other 16 beds, Karen.
Yeah. So, you know, if you, more detailed questions are probably better to Ashley Berliner, but I did, you know, we have had conversations about this. She doesn't, at this point, it doesn't sound like that's something that she thinks is going to happen, that she's not getting that indication from CMS.
Doesn't think it's going to happen.
So we could put in language asking for.
But we did put in initially. So part of the reason we originally didn't name VPCH, and we did that strategically, right? Just in case we needed to pivot and have it somewhere else. I forget which committee it is, but someone on the House side wanted to name, I think it was the House side, wanted to name VPCH. So that language was put in there, but we asked to make sure it said initially, so that if we did have to pivot, the language was in there that would allow us to do so. So we are trying to be conscious of that. We don't think there's a very high chance of that at all, but we did try to add some language that would give us that flexibility if needed.
And also, if CMS says no and you want to proceed, CMH would have to come back to us in the budget process to ask for general funds for those 16 beds.
Yes, absolutely. Yep.
And we could put a stop to it then.
Yes. Yep.
And CMS never just yanks your funding. They submit a corrective action plan. You have years to correct.
I get that. But we're working on a waiver right now.
Right.
That waiver is ending.
Right.
And I'm just
Yeah,
concerned
no,
about.
that's a good question. And so I think the
Losing
answer
the whole
is,
thing.
yeah, so I think the answer is if CMS said, okay, 16 beds, you now have to pick up the whole thing for that too, because you did these 9, that has to come back to us in budget process before this goes any further.
Which budget process?
Next year.
Yeah.
Yeah. Leslie?
This is
And then
very,
we do want to stop.
yeah, I get it. This is a very quick question about the CON. I think the language says any forensic facility, and the question came up about a future forensic facility. And I'm wondering if we could separate it out, or if we could think about just applying it to this forensic
We
facility.
absolutely can. That's our policy decision.
Yeah, so that's what, yeah.
Yeah.
That's page 2, yeah.
Okay. All right. Thank you, Karen, so much. I know you're back with us at 3. I am actually going to add to the agenda this afternoon, sorry, Claire, a committee discussion on S89. So we're going to do 47, and we're going to keep talking about this because I have to check in with judiciary and when they need us to say we're good or not. So Karen, just to let you know that. And thank you very much.